Hello, everyone. Thank you for joining us. And I hope everyone is staying healthy, safe, and sane after the crazy year that we've all had. My name is Jane Schvetz, and I'm a partner in the White Collar Defense and Investigations Group at Debevoise in Plimpton. We have a wonderful panel here today to discuss anti-corruption compliance risks in the countries of Central and Eastern Europe, focusing in particular on counterparty due diligence. We talk a lot about Russia and CIS countries when talking about anti-corruption and compliance topics, and that tends to overshadow a little bit the countries to the west of those. I think, and I think everyone on this panel believes that they deserve more attention than they tend to get for two reasons. First, corruption risks are significant in these jurisdictions. And second, foreign investors and multinationals looking to operate in these markets may be lulled into sort of a false sense of security because these countries belong to the EU, having a sense that you don't need to be as alert to these risks as you might otherwise be. So before we begin, let me introduce our great panel. And first, to start with the Theiss team, we have Valerie Hohenberg, a partner in Theiss's Vienna office, specializing in cross-border litigation, corporate investigations, and white-collar crime. Valerie regularly advises companies on internal investigations by Austrian and foreign authorities, and on compliance due diligence. We also have Oleg Temnikov, who is counsel in the Sofia, Bulgaria office and is often involved in domestic and international arbitration proceedings and complex cross-border disputes, including white-collar and corporate investigations matters. Based in Budapest, partner János Tóth has significant experience with corporate competition and compliance matters. He regularly advises clients on designing and rolling out compliance programs and policies, as well as whistleblower procedures in areas such as anti-bribery, antitrust, and data privacy. And last but not least, Cecilia Popescu heads Theiss's dispute resolution team in Bucharest, Romania, and often advises multinationals and investment funds on complex cross-border litigation and arbitration cases in a variety of industries. And on the Debevoise side, I am joined by my colleague, Constantine Bureko. Costa and I frequently work together on matters involving Eastern Europe and have had a pleasure to work with Theiss colleagues on such matters, including a large investigation that completed earlier this year. Importantly, following this webcast, all attendees will receive a CLE form and associated documents. If you want to claim CLE credit for today's session, I will announce a 5-digit code at the end of the hour. And that's the code you will need to use on the form when you fill it out. So let's begin by saying a few words about US and UK anti-corruption legislation and its enforcement in particular as it relates to CEE countries. I won't go here into kind of the statutory language of the Foreign Corrupt Practices Act, which is the flagship US anti-corruption law and also the oldest. But there are two key aspects of the FCPA and its enforcement that I wanted to emphasize to set the stage for our discussion. The first is the broad jurisdictional reach of the FCPA. Where an alleged bribery scheme has any connection to the US, there could be jurisdiction of the US authorities. It's of course more complicated than that, and there are nuances, but it is a very broad scope of application. This includes situations where a US person or a US company is involved, but also situations where sometimes no US persons are involved, but there is some action in furtherance of the bribery scheme that allegedly takes place in the US. And these days, with the way we all do business and have done for many years, oftentimes it's kind of an electronic connection rather than a physical one. So for example, if you have a payment in US dollars that is routed through a US bank account, that would be considered a touch point with the US that could lead to jurisdiction. or if you have use of email or other electronic means of communication that are based in the US, such as, Gmail servers, for example, that again can be viewed as a US touch point. So that is the first kind of aspect, this broad jurisdictional reach I wanted to mention. The second is that US prosecutors take an expensive view of the so-called mens rea or mental state that the defendant must have in order to commit bribery. Most relevant for our purposes today, a company can be held criminally liable for bribery where the bribes are paid by a third party acting on the company's behalf, so long as the company knew or should have known that the third party would engage in misconduct. And that should have known is doing a lot of work here, because that's where a lot of cases are. It's often the case that we're dealing with red flags that are ignored or information that isn't fully followed up on, as opposed to kind of true direct knowledge that a third party is committing bribery on the company's behalf. And this, of course, underscores the importance of due diligence and active monitoring of counterparties, including joint venture partners, folks from whom you acquire a company, folks with whom you do business, etc. In fact, outside of kind of gifts and entertainment context, the vast majority of cases, of FCPA cases, involve third-party bribery. So bribery that is done not directly by the company or even its employees, but by others on its behalf. And there are two recent enforcement examples that directly relate to CEE countries to illustrate these. In one case, an Israeli company allegedly hired two third-party intermediaries to assist with obtaining building permits in Romania. The US authorities alleged that the company did not conduct due diligence and that on these intermediaries, and that there was no proof that services were rendered. Because the company was listed on New York Stock Exchange and therefore subject to FCPA's accounting provisions, it had to pay a civil fine in that case. And it underscores the importance of due diligence and third-party monitoring. Another case involved Hungary and Microsoft, and another kind of large matter involving Central and Eastern Europe from recent years. There, the bribes were allegedly paid through discounts to resellers and licensees of Microsoft software in connection with government tenders and government contracts. Again, in both of these cases, the main US nexus was that the companies at issue are listed in the US and therefore subject to broad requirements of the FCPA, including its accounting provisions. But both illustrate kind of the reach of the US authorities and the importance of carefully vetting third parties. And let me turn this over to Costa to say a couple words about UK practice and enforcement in this area.
Thank you very much, Jane. So the reason we wanted to bring up the UK is because, in a sense, second to the US, they're probably the most active in actually trying to enforce extraterritorial corruption whenever it relates to UK companies or companies with any business in the UK, which is quite a broad category. So since 2011, the UK Bribery Act has been enforced and created an offence of failure to prevent bribery by associated persons of corporate entities. This offence is really the flagship new power given to UK enforcement authorities to try and catch bribery in a very broad sense. And there are two real key elements of this regime that have a lot of parallels to the US regime. So the first is the mental element, in the sense that this failure to prevent offence doesn't have a mental element. As long as a person associated with a company, and that's a very broad concept, catching things like employees, agents, and subsidiaries, committed bribery in order to win or retain business for that company, they are guilty of an offence, even if the senior management didn't know, even if they had no way of knowing. That is only tempered by a defence, which is that you had adequate procedures in place to actually prevent bribery, and we'll talk about some of the elements of what helps establish that defence slightly later on. The second element of the regime is that the associated persons who are potentially paying the bribe don't have to be convicted of any UK criminal offences. They don't have to be in UK jurisdiction at all. So this can be committed by your subsidiaries anywhere else in Central Europe, anywhere else in the world as well. One major difference as well from the FCPA approach is that the UK Bribery Act goes beyond just catching bribery of government officials. It also criminalizes commercial bribery in exactly the same way as the FCPA criminalizes public official bribery. Now, when talking about enforcement of this legislation, seeing as it's only come into force since 2011, understandably, there is a much shorter track record. Also, just by the nature of UK markets, there are perhaps fewer international companies based in the UK or operating in the UK in the same sense as compared to the US. Having said that, there have already been 6 deferred prosecution agreements, which are a form of settlement negotiation entered into with UK enforcement authorities, and 2 criminal prosecutions under this failure to prevent bribery offence. Now, to date, none of them have covered CEE countries specifically, although there's been one recent deferred prosecution agreement that actually covered Germany and Austrian business that was effectively headquartered in the UK, which does show that the UK authorities are pretty much looking anywhere in the world for opportunities to prosecute and hopefully prevent bribery and corruption. So with that said, I'll turn over back to Jane.
And I think we're actually going to Valerie now to give us a bit of an overview of CEE and relevant aspects of the legal regimes there.
Thank you, Jane. Good morning and good afternoon, everybody. A brief outlook for CEE. Corruption is one of the most widely covered topics in CEE media. We often read about high-profile investigations and even convictions of former politicians across the entire region. But as we all know, corruption is not an exclusive habit of government officials. It happens even more in the private sector. Of course, corruption in the private sector doesn't have a similar media coverage simply because such matters are often handled by internal investigations, which are generally confidential. In CEE, the number of internal investigations is increasing due to the fact that we see the introduction of many new laws to fight bribery and corruption, in particular at the criminal level. This has been a clear trend over the past few years, not only in international law, but in particular in CEE. This new legislation includes rules of all sorts of corruption, the protection of whistleblowers, civil liability, regulatory consequences, like, for example, the exclusion from tender procedures, and very important, corporate criminal liability. Most CEE countries have taken big efforts to implement such laws. The biggest incentive for all these developments in our region is to attract foreign investments. It goes without saying that by such efforts, such efforts can't be done overnight, and that international investors already have many countries on their lists, but they have to become even more attractive. And such a change can, of course, not happen overnight, and it takes many steps to implement new rules that further extend the responsibilities of companies for the acts of the people and to trigger the implementation of compliance systems, for example. In Austria, the duties of a corporation are stipulated all over the legal system, mainly in the civil and administrative law. A violation of this might lead to criminal liability of the individual, but also of the corporation itself. A solid and well-implemented compliance system might reduce the risk to mitigate corporate criminal liability, or the other way around. Further, the lack of a compliance system might even lead to a criminal liability of a corporation. This is the learning that corporations in our region are currently undergoing. But it is not easy as this sounds. The management of third-party risks is one of the bigger challenges that CEE companies face in the field of bribery and anti-corruption. In fact, it is difficult for companies to conduct a top-down bribery and corruption risk review and risk assessments. The difficulty is that a comprehensive assessment requires money and manpower and the willingness to invest these resources. Definitely, we often perceive lack of these resources. And these are just a few headlines of the local challenges, which will now be covered by our following Q&A.
Thank you very much, Valerie. Speaking of Q&A, I think we'll launch right into it. And I should have mentioned at the outset, please submit any questions you have using the chat function. And we will try to get to them at the end of today or during the presentation. If we cannot, we will reach out after today's webinar. And with that, my first question is to Oleg, János, and Ligia in connection with Bulgaria, Hungary, and Romania in particular. And let's say you're dealing with a compliance due diligence in connection with a transaction in your country. Kind of what are the key local issues in play when it comes to uncovering red flags? How would you go about obtaining the information, as full information as possible about the company that you're acquiring? And what would you say are the greatest risks in terms of the blind spots that investors may face? And let's go to Oleg first.
Thank you very much, Jane. Good afternoon to everybody. Well, there are of course particularities very clearly outlined by you and by Valerie when speaking about Central and Eastern Europe. As it concerns Bulgaria, we have the luck to have a jurisdiction in which it is rather developed electronic registers. So as a first step, as the very first step, we are in a very good position to check a number of data on the activity, on the history, on the operational history of a company through public register. So it is always the first check we do, and it is very useful because it could be relied in any subsequent procedures, even if you go in investigations in other jurisdictions or internally. Now, we have, of course, our checklist, which is based on public sources, on, of course, the commercial register, which is quite detailed now from the last 2 years, from the UBO registers, in the solvency register, which all of them provide a piece of the information of the operational history of the company. Now, of course, they provide the first layer of data, so they are essential to be performed, but absolutely not sufficient to be performed as checks. So we rely very often on privately run databases which aggregate information from various public registers for all kinds of licenses, of permit, of authorizations, which are public, but they are aggregated in one space, in one solution, and with these two we can verify. The interesting thing with companies in CEE, which we see at least in our jurisdiction, is that they often have changed during the years their focus of activity. So we can have a situation where a company has participated in public procurement. We can identify other activities of this company, and it's where we come the interesting part, because we can discover shady or at least matters which are worth be further research. And I give immediately a good example. We had a case where we were making a due diligence of a company, in this industrial company, and we identified waste recycling business in the past, which of course brings another layer of risks and things to be analyzed. So here is exactly the experience, the expertise of the local lawyer to know where to dig in a specific case. So checklist, public sources, but the local expertise with the specific areas, I would say public procurement and all other registers which can identify.
Thank you, Oleg. János, over to you.
Yes, thank you, Jane, and warm welcome to our attendees. The case for Hungary is not largely different from what Oleg explained. However, the big difference and in a way a drawback in Hungary is that the government is lagging behind with setting up the UBO, the Ultimate Beneficiary Owner Registry. The deadline for doing this on the basis of mandatory European laws has long passed, and still there is nothing on the horizon when we would expect to have that register set up in Hungary, which would very obviously largely extend the possibilities to really look into the not only to the shareholding but also to the past history of the company in many ways. In particular, if they have been exposed to politically affiliated persons in some ways. On the other hand, however, in Hungary, the public registries are very reliable, and local laws encourage, more than encourage, the local business players to keep the relevant data up to date in those public registries in order to make those rights and facts not only applicable but fully enforceable vis-a-vis third parties. So therefore, the Hungarian system, public administrative system, in terms of the corporate good standing, insolvency, collateral registry, land registry, even court cases, or historic financial performance data, the availability of the registries and the reliability is a good source of conducting counterparty business partner diligence. The Hungarian public administration has been working online for some years now. Again, a very conscious development that our government has put on its on its agenda, and notwithstanding the pandemic that we are facing and forcing business players into the online field. So when interacting with the state, again, well, by now, mostly everything needs to be done online, which again gives a very good access to historic filings and all interactions that the business players might have had with the state or state administrative bodies. And on the flip side of this is that the state is not only generating but making available the relevant data. And in addition to what I mentioned, I could add here environmental pollution history, or other sort of breaches of laws in connection with public utilities, public infrastructure, for instance. So these all would be available and reliably searchable in Hungary. And of course, much will depend how that huge amount of data is then reviewed and digested by local council. I think that in a nutshell, that's the good case for Hungary, and I think I'll hand over to Ligia in Romania. Ligia, you need to unmute yourself.
Sorry for the technical issues that we cannot avoid sometimes. I hope everybody hears me right now. So for Romania, the economic forecast for the year 2021 has been surprisingly favorable, with some institutions like the IMF going up to a 6% economic growth estimation, meaning that the country is very interesting again for foreign investors, meaning that when you are trying to set up a greenfield investment or to acquire control in Romanian companies, you need to be very careful with the way in which your due diligence goes. You have to hire local lawyers that can guide you through the whole procedures and through the various pitfalls of these procedures. And you need to bear attention to the information which is publicly available, combined with the information which is, of course, disclosed to a certain extent by the seller. So as far as public records go, the situation is overall similar to the one described by my colleagues, in the sense that you will have a wide variety of public records available for the purposes of your due diligence, such as the trade registry, the UBO registry, which are both reliable sources. Sometimes the registrations in the trade registry may have slight delays with reality, but nevertheless, this is not often encountered in practice. So pretty much everything in the trade registry is very reliable information about corporate governance, financial situation, potential insolvencies, structure of the management of your target company. Similarly, if you are targeting a company owning immovable assets, you can rely upon the land registries showing you ownership titles, the history of such ownership titles, and you can also use collateral registries and security electronic registries that will also indicate to what extent that immovable asset may be encumbered by any sort of security. Furthermore, the court websites are pretty good in terms of showing you whether the company is involved in any litigation and which is the exact status of that litigation. But one important issue and potential pitfall that you have here may be related to the existence of criminal investigations over your target company for corruption. Here, the first phase of the criminal investigation is always confidential. It is carried out by police and the prosecutor jointly. So before going to court, before being presented to the judge, the entire investigation is confidential, and therefore it will not show up in any public records. Therefore, for the purposes of having an accurate image over your target, you will have to rely upon disclosure from the seller and also through the media reports that can sometimes reveal very interesting and relevant information which is not publicly shown in any public ledgers. So all in all, it is in general a reliable jurisdiction with information which is very valuable and reliable from public records, from the media, from other sources. So I don't think that there is any particular concern that should be taken into account when analyzing whether the publicly available records are an important and reliable source of information. Thank you.
Thank you very much. And it's interesting. It sounds like the press and the media sources in your jurisdictions are generally viewed as reliable, though of course I assume this is another area where local council would be very helpful in navigating the what is and is not reliable. Something we deal with a lot, Costa and I, is this the issue of kind of black PR. And a lot of the public information, especially in sources, again, kind of east of you, being very unreliable and sometimes purposefully throwing in corruption and other allegations against competitors or otherwise to kind of further their own ends. Is that maybe just to throw it back to Ligia covered this a little bit, but for Janusz and Oleg, is this something you're seeing in your jurisdictions, and how do you advise clients to navigate that?
Yes, if I may reply. As to Bulgaria, of course, we have a huge issue with black PR in media, and over the years, what we have experienced is that often targets have some records, at least in the past, of such situations. So almost in each analysis we did, we discovered something to be checked. Now, considering the particularities of this market, we always advise our clients to make such a review, to further investigate such allegation, because in most of the cases there is a part of truth in what has been said, but it's important to establish what exactly has happened and provide the appropriate legal qualifications on the local law. So usually what we do, we have a look, we then verify the facts from the publicly available registers and data, and make a high-level legal assessment. Now there is another point, is that certain practices, especially in the past, especially prior to joining the European Union, may have not been exactly with the same legal qualification as now, with the same degree of legal risks as now. So here again, it's the local lawyer to guide the client in this. And we are happy to do this to the extent that the client really wants to go into this detail for its compliance needs.
Yes, and if I may, from the Hungarian angle, the scenery has been drastically changing, I must admit, and apparently as news can relatively cheaply and effortlessly be spread around in social media and in other platforms, which then relatively quickly picked up by more conventional media. The threat or the exposure to such black media or black PR is becoming more and more relevant in Hungary as well. Obviously, the cautiousness anyone would need to take here is to avoid reliance on such third-party information, and or filter it through a good, sensible pair of eyes, and as Oleg mentioned, perhaps see ways how private additional private tools and investigatory techniques can further confirm or otherwise, fulfill that type of black PR that someone might have received in Hungary. Probably that's the fair summary.
Thank you.
Yeah, if I may just add very quickly. So what I was trying to say, it's not that necessarily these media sources are reliable, but they are for sure a valuable starting point in your due diligence efforts, because they may reveal information which is not publicly available, because let's say there is a criminal investigation ongoing, but it is in its very early stages, whereby information is not available, but still media, through their specific sources, they can give you a very good hint about what it may be going on in relation to your target. And I have to say that it happened to us several times, when starting from some red flags mentioned in the media, we were able to deepen our researches through specific lawyers' means, and to be able to provide the client with a more complete picture about what's going on with their target.
Thank you. That's very helpful. And we received a question about whether there is sort of a checklist for due diligence that can be used. And I'll say, the short answer is yes. And I think most of us who work in this field and who advise companies on anti-corruption due diligence we do not start from scratch. and we do have kind of the list of information that we normally would receive. That said, I think it's also important not to over-rely on these pre-existing checklists and not turn this into a check-the-box exercise. One important source of information is other types of due diligence. So even the due diligence that isn't aimed at anti-corruption and that issue can reveal a lot. So usually folks would request major contracts, for example, or HR information or other information for other areas of due diligence. And all of that can be extremely useful also to inform your understanding of the anti-corruption risk. Who are these third parties? Where are the major contracts? What are the HR issues? Are there whistleblowing issues, for example, that may come through the HR due diligence that are important? And then the other issue, and I'll turn it over to Costa to discuss, is sort of the internal information that you as an investor may have. So Costa, would you like to address that?
Thank you very much, Jane. So absolutely, and one common failing we actually see of some companies' policies and procedures for dealing with due diligence on third parties, whether it be in a merger and acquisition scenario, a transaction scenario, a joint venture scenario, is that they forget that an equally valid source of information on potential red flags and the risks associated with their counterparty is their own internal sources. And here really there's two elements I want to very briefly cover. The first is human sources, so employees that have previously transacted with that counterparty. Even if it's, say, a merger and acquisition, prior to the acquisition, you may well have had other dealings with that company. Maybe they were a customer, maybe they were a local supplier. And you want to make sure that you involve the right people with that experience in the due diligence process and get the relevant information from them in case they are aware of some red flags that otherwise you might not catch from these external databases. After all, they've actually had personal dealings with these counterparties. The second type of information is actually just records. Now that might seem obvious, and most companies will have very effective ways of keeping archives in place of previous dealings, letters, correspondence, transaction history, etc. But it's important to go back to that archive and actually check it if you've previously had dealings with your counterparty due diligence target. We have had situations where a company might have decades of experience dealing with a counterparty and had numerous red flags on file, but because they didn't fully check those archives when entering into those transactions, they missed those key elements that would have really informed their due diligence process. And if you do have those things on file, make sure you actually use them and have a way of integrating them in your due diligence process.
Thank you, Costa. Valerie, unless you have anything to add, I was going to move to our next question, which is about we talked generally about counterparty due diligence in these jurisdictions. Are there particular industries or types of companies in your experience that kind of present unique issues and unique problems from anti-corruption perspective, more broadly and specifically from the due diligence perspective? And let's start with you, Oleg.
Yes, of course. Of course, there are industries which, per se, when we see a client seeking an acquisition in these industries or operating in these industries, we would definitely recommend enhanced due diligence. Of course, we would say that these are first the areas that are involving. Sorry,
Do
Lydia,
you mind going on mute? I think that's causing a bit of a feedback.
Thank you. So, of course, these are the sectors which are related to the. Apologies, Lydia, could you microphone? Thank you. So these are, of course, the sectors which are closely related to the state-to-state activities, because these are the ones where we have seen most often issues or concerns of corruption, of bribery, or some other sort of irregularities. We would say all sectors which are related to public procurement, to public buying, which are construction, concessions, arm trade or arm production, pharmaceuticals, or any similar sectors. But it could be also IT projects, companies in IT sector which have worked for the state. So If we see that a company has been highly involved in public procurement or dealing with the state, it's always advisable to go to make a check. Often we can identify politically exposed persons within the management of this company or somehow related to this company, which also is a situation which is worth mentioning and going to the client with this. But in these sectors, definitely enhanced due diligence, enhanced review, it's recommended. And especially if we see a high intensity of corruption or bribery risks or risks for the client like insolvency, we will be happy also to help the client by guiding it to specialized companies which can provide even further levels of investigation if we would see such risks. And maybe I can switch to Janos.
Yes, thank you, Oleg. Unfortunately, no miracle from the Hungarian angle. Indeed, biggest exposure we normally see in case of targets or companies that are engaging with the state and sourcing business through public procurement. Jane mentioned at the outset probably the biggest case causing huge waves in the bribery area in our region, the Microsoft case with Hungary, which indeed involved also some business granted through public procurement arrangements to Microsoft. The other area where what I would single out is probably the availability of state or even EU funds and subsidies, the state aid, which apparently is flooding to the local business players. Our governments, not only in Hungary, but throughout the whole region, are very much encouraged to help businesses to grow and invest and even acquire their competitors through handing out subsidized loans or other forms of state aid. And certainly we see a risk area in that regard, especially if certain intermediaries or third parties are involved in those subsidy arrangements. So that would be a very definite particulate for Hungary. Asia, anything to mention from your angle?
Yes, definitely. I mean, we do have certain industries which are similar to the ones that the European Union has identified for a number of countries, such as real estate, for example, construction, transports, but also different types of activities carried out by investment funds, and other industries which are prone to either using proceeds from money laundering activities or just triggering and engendering even more business which can be used for these purposes. There are also certain types of transactions that I would like to refer to, like transactions with offshore destinations, whereby obviously the legal regimes are more relaxed than the ones that we have here in the European Union, allowing for a more relaxed, if I may say so, regime in terms of being able to control all these activities, transactions with shell companies in various destinations with the same issues, bearer shares and checks. For example, in Romania, there has been recently, a ban to any bearer shares utilization and this type of activities. Alternative money transfer systems also have been found to pose significant risk. And then also the usual culprits, casinos and gambling activities, including online gambling, online banking. Unfortunately, also in some instances, public notaries and lawyers have been indicated as a potential source of risk from this point of view. Retailers, for example, of cigarettes and beverages, alcoholic beverages, have been found to be heavily involved in corruption practices. So unfortunately, yes, there is a very vast array of industries and types of transactions that will trigger risk in all jurisdictions, I think, not necessarily only in one country or in a group of countries. So I think from this point of view, it is necessary to take a look initially at the industry and to evaluate very clearly the potential risk that may be triggered by trading into that particular industry. Also, like a last comment for Romania, energy players and their activities have been unfortunately also recently involved heavily in corruption accusations, and there have been efforts from successive governments in Romania to privatize minority packages in state-owned companies, for example, in order to allow access to more transparency and more information in relation to the activities pertaining to renewable energy, traditional energy sources, and so on and so forth. So therefore, the analysis from this point of view should be twofold. One is concerned with the intention to acquire through a privatization procedure, for example, a certain participation in a state-owned company, and then also the acquisition in private companies should also take into consideration the type of industry you are targeting and the type of criteria that I have mentioned.
Thanks very much. That's very helpful. And maybe just to add, you know, another issue we've seen and kind of an area potentially to look out for is companies that have recently changed ownership, and just generally looking at the ownership history further back from just whoever you're buying the company from. What we have seen in a number of cases is where a Western investor, PE firm or other investor acquires a company, Central and Eastern Europe, and essentially westernizes it for sale, including, among other things, usually putting in place some sort of compliance program where none existed before. Unfortunately, depending on the period of time that investor holds the company or what they do, it can be a rather superficial job. And it may be important to kind of go beyond one step sort of before the current owner to really understand what the situation was at the company and what has been done, and the extent to which the compliance program the company may have is just something written on a piece of paper, or if it indeed has been implemented in that company. What we see is sometimes foreign investors who then buy from these Western funds may give too much, may put too much stock and take too much comfort from the fact that kind of a well-known, you know, Western investor with a compliance program had owned that company before, and just take their word for it, or essentially assume that the compliance policies that are in place on paper have been implemented. And oftentimes that may not be the case. And problematic practices from the past may well have been continuing. With that, let me turn it over to Valerie for some additional questions. I know we're running low on time, and to the extent other questions come in, we'll probably take them offline after the webinar.
Yes, I have a technical question to you, Jane and Costa. Let's say you're an investor who is subject to the jurisdiction of the FCPA or the UK Bribery Act. You conduct the due diligence on your investments or business partner and decide to proceed with the transaction. What should you be doing immediately after the transaction to make sure you don't run afoul of the FCPA or the UK Bribery Act? What should you be doing as you continue to operate your investments? Jane, do you want to start? Or Costa, sorry.
Sorry about that. I jumped straight in there. I was just going to say that, first of all, you have to see due diligence as not just a process that stops as soon as the acquisition completes. There are going to be some elements of the due diligence process that you can just never really do satisfactorily just as an external buyer or someone entering into the transaction. Once you say, actually, own this subsidiary, own this company, that's when the real process starts of getting into the weeds and making sure that you don't have any ongoing compliance risks that after the acquisition become your problem. And although US and UK authorities do give you some breathing room as soon as the acquisition finishes, they're not going to be very impressed if you allow corrupt conduct to continue by that newly acquired subsidiary, by that new joint venture partner, depending on the type of relationship with that you have with them. So usually it's really as soon as practical, you should go in there, make sure that you establish sufficient compliance systems and controls, integrate them into whatever global systems you have, where it's appropriate to do so, and whether the systems actually make sense working on that local level as well. The other element I wanted to emphasize, and the real benefit to continuing that due diligence mindset even after the acquisition, is that often as part of an M&A deal, you might have indemnification provisions, warranties and the like from the seller. They will often have a time stop on when they stop operating. So you need to find out what those issues are, find out those hidden liabilities while you still have time to make claims from the seller under those warranties where it's appropriate to do so. All of these elements as well are going to be important to helping show that you have sufficient systems and controls in place to detect, monitor and prevent bribery and corruption, which is a factor when the US looks at prosecutions. And also, as I mentioned earlier, one of the ways you can establish a defense under the UK Bribery Act, so having adequate procedures in place to detect and prevent bribery. I'll hand over to Jane for some more thoughts on this one.
Sure. We actually got a question about whether a historical red flag should it stop a transaction or how to deal with that. Of course, there are many times when red flags do exist and they do not stop transactions. I think in an ideal world, you want to identify those red flags before you do the transaction for a couple of reasons. First, to know what you're getting into and be prepared to remediate, as Costa has been saying, immediately following the acquisition. And second is there are cases when those red flags, depending on what they are, can actually materially impact the price of the transaction. If there are particular business relationships that would need to be severed, would need to be stopped, contracts that would need to be ended as a result of compliance risks, obviously knowing that before you proceed with the transaction, even if you choose to proceed with it, is important from commercial perspective. That said, it's not always possible. And again, to emphasize what Costa said, the really important aspect there is to make sure you then immediately remediate. What we often see is there's kind of an M&A team that's handling the transaction itself. They work very hard. They get the investor to the signing, to the closing. Then they all invariably take well-deserved vacation. And then a new team comes along that then is supposed to kind of, sort of manage day-to-day interactions with that company, potentially some folks who go on boards from the investor, who join the board of the subsidiary of the acquisition, but they may be completely and often are a completely different group of people. And it's important that whatever the learnings, the lessons of the due diligence process, the red flags identified, the good, the bad, and the ugly, is actually then communicated to these folks so that they're not starting with a blank page and that they know what needs to be done following the acquisition to ensure that the problems don't persist following it. I know we're close to the top of the hour, so let me just give folks the CLE code, which is 21225. Let me repeat that, 21225. And perhaps folks from the events can even put that in the chat function for all attendees so that you have it. just to finish up, one other question we received was around ESG due diligence. It is something, the short answer is yes, ESG due diligence is something that is very much on the mind of many investors these days. And both Wolf Theiss team and us at Debevoise have done extensive work on this issue. And Debevoise side, we have an ESG group now, cross-practice group that deals with these sorts of issues. And I will follow up. We will follow up following the seminar with some resources. It's a topic all of its own that we certainly won't be able to cover in the few minutes we have left. With that, and maybe as a last question, I just wanted to ask Valerie, perhaps you, regarding the corporate criminal liability. So, we've been speaking about, we've said a few words about US and UK laws and the reason, the broad jurisdictional reach, etc. But what might companies face in terms of criminal liability in these CEE countries?
So it's the corporate criminal liability in Austria. It was established in 2006, and it is very important when internal investigations are starting in a corporation, that you always have in mind the threat that the public prosecutor is starting with investigations also against the corporation. In Austria, for example, the sanctions are rather low, but it's a reputational risk, and clients we have to be really very careful that the public prosecutor is focusing on the people involved and not on the corporation, because this can have a huge impact on investors. And we have, as I said it before, we have it in most of the CEE countries. Apart from, I think in Bulgaria, we don't have, it's always administrative sanctions, right? It's not.
It's just fine, which is administrative sanctions, and they are separately investigated. It's not criminal liability.
Yeah. But to summarize it, you always have to have it in mind when it comes to internal investigations, that the public prosecutor can start with the investigation against the company.
That I think we're right at time. So thank you very much to all the panelists, and thank you to all attending. We are our contact information, I think you have, we will include it also in an email follow-up to everyone along with the CLE forms. The code again is 21225, and thank you very much for attending.